Yo YouTube, what is good? It's your boy Lawless back here again, and today I'm gonna cover federal rules of evidence. Gonna talk hearsay and the Confrontation Clause. Um, so let's start with hearsay. Basically, we have out of court statement used to prove the truth of the matter. So you're gonna want to remember those three things. So you'll have under 801, it should define like out of court statement. And out of court is just anywhere. It's not on the witness stand. Statement is it could be oral, it could be written, and it can be nonverbal conduct intended to make an assertion, and then to prove the truth of the matter is just to say, what you're asserting is true. Yeah, I'm sorry, that's probably bad to use the same word, but I can't really use the word honest because that's truth and honesty are actually two different things here, which is a tangent for another time. Declarants, they are the person who makes the statement, and then 801D, statements that are not hearsay. You have these categories that are just, or this is categorically not hearsay. So a declarant witness's prior statement, it can be a consistent statement, it can be an inconsistent statement, but it's important that their declarant is testifying, is subject to cross-examination, and then the statement either is inconsistent or consistent. Sorry, I got the little hiccups, man. An imposing party statement is just a party to a litigation who makes a statement that's not hearsay, so it can come in. Remember, hearsay is like you're keeping it out, and unless you meet an exception, or categorically not hearsay. But yeah, opposing party statements. If you make the statement, a representative, let's see, the party manifested and then adopted. Oh, if you adopt, in like a statement, if someone says like, "Oh, Lawless, that's the coolest guy ever," and it's like, I don't say anything, but I adopted it because I'm not refuting it. If a reasonable person, especially like if a reasonable person in that situation would deny such an claim, then it'll be like you're adopting this statement because a reasonable person otherwise would not adopt that or would not accept that statement being placed upon them. Right. So then 803 is like exceptions. Let's see, we got present sense impression. That's really based on the event or condition occurring, and the declarant is perceiving it, and is making that statement contemporaneous to the condition occurring, or their perception of that condition occurring. Then excited utterance. You have that event or condition, it occurs, declarant makes a statement, and they have to be under the stress of that excitement. That'd be like, if you have someone high speed chase and the cops following them, tailing them, and then they get to the little, I'm sorry, this is a real world example, but we call it like a toll road, but the gate's down, so the person ends up stopping the vehicle, and they had a passenger in there, and the passenger is like, "Oh my God, I was so scared for my life," because of the excitement of the event that just occurred. You know, you will use that excited utterance exception. And it's not necessarily that you have to like be that close to the event, You just still have to have the stress of that event to allow that statement in. Then existing mental, emotional, or physical condition. Basically, you just need that statement to be like, again, like contemporaneous. You don't want it to be coming from memory. So if someone's like, man, my arm really hurts right now, then they're making a statement of their existing condition, right? But, you know, if you went and said like, oh yeah, I remember yesterday my arm was hurting, that no longer is an exception. Next is a statement made for a medical diagnosis. That basically is, this kind of allows, like, you know, if you said so and so like did XYZ, like they hit me, they broke my arm, whatever, and but it's like you're telling your medical professional for the purpose of diagnosis, then you know it can be admitted. Now, if you're telling them because you're like looking for to like use it at a trial, it won't be admitted. But we'll get to the Confrontation Clause after. Recorded recollection. That is like if you had a written statement, say you made to the police, and you write down, you know, this event, and you can get that admitted into evidence, assuming that there's what's contained within that statement isn't barred by another like hearsay, like present sense impression or excited utterance, you know. But yeah, you do have layers of hearsay within hearsay that you do analysis on. Records of regularly conducted activity. This is kind of like just showing that kind of like in Rule 406, if you got there yet, about habit. But like a business would have a habit of keeping a record. So someone with knowledge makes that record at the time or near the time that it occurs, and the business has a regular practice of that activity, and it's in the course of regularly conducted activity, or the record is in the course of a regularly conducted activity. Then 7, yeah, so 7 is the absence of a record, and you're just saying like, hey, because there's not a record of this, it probably didn't occur. 8 is public records, and you know that's for like public offices. Specifically though, when you want to remember that for criminal cases, police officers like report isn't admissible. You're gonna have a confrontation clause issue for that. So yeah, but barring the criminal case, the public record is usually an exception that's good to go. Then Rule 804 is declaring unavailability, and the person can be unavailable if they're like exempted to testify, they refuse to testify, and despite like a court order, they still refuse. They can't remember. They can't be present because of death, injury, infirmity. And then is absent from trial and the statement's proponent has not been able by process or other reasonable means to procure declarant's attendance. Kind of like, oh, this probably takes you back to like Civ Pro, but you guys might remember a Prenoyer case, and when he was trying to serve him with notice, but he like did it on it was like a little newspaper or something like that, in the state of Oregon. The guy was like in California, would have never known about it, and it's like, oh, improper service. That's kind of what that portion is about. And then 804B was the exceptions. Excuse me. Exceptions, so former testimony. Alright, I'm back. Had a cough really quick. Former testimony, or exceptions to hearsay. So former testimony. So if there was like a witness was at a trial, and then there was like opportunity for direct, redirect, cross-examination, that statement can be used as hearsay, or not, can be used and admitted in evidence, and not be excluded by hearsay. Then statements under the belief of imminent death. So this is like kind of part objective and subjective, that the person believes that they're dying. A reasonable person would believe in that situation, would believe like they're dying. So like say you got stabbed and the doctor's like, man, I don't think he's gonna make it, man. You make some statements like, oh, Johnny done stabbed me. Elizabeth, I'm coming to see you. That's would be a statement, under the belief of imminent death. Statements against interest. It's just like if you said something that a reasonable person wouldn't say, because you're making that statement because it's true, or it's just. Actually, hold on. Let me read this rule to you, because it gets weird. Reasonable person in the declarant's position would have made only if the person believed it to be true, because when he made it, it was so contrary to the declarant's propriety or pecuniary interest, or had so great a tendency to invalidate the declarant's claim against someone else, or to expose the declarant to civil or criminal liability, and is supported by corroborating circumstances that clearly indicate its trustworthiness if it is offered in a criminal case. Okay, so yeah, your statement is like, well, that would be, you don't want to claim that statement. A reasonable person would want to claim that statement. So basically, I think we talked about, adoption. So like adopting a statement is like, it's different because you're not actually making that statement, but there's like times if your silence is not golden. Having someone say, oh, he's a bad guy, and you don't want to adopt that statement, so you would say something. But statement against interest is like you just stating yourself, like, oh, I'm a bad guy. And then another exception, I guess, the last exception, not the last, but for what we learned in class, statement offered against a party that wrongfully caused the declarant's unavailability. So if they have a statement, but you're like, hey, maybe you went to their house, and you're like, ooh, that's a nice home you have. Be ashamed for something to happen to it. I guess you shouldn't show up to trial Tuesday, whatever day. So you intentionally and wrongfully cause that person to be unavailable. That's their statement against you can still be used, and without violating the Confrontation Clause. The Confrontation Clause is under the Sixth Amendment, and it's just the defendant's right to, well, this is for criminal trials only, but defendant's right to confront the witness or people testifying against them. And your main doctrine for that is the Crawford v. Washington. Basically, a man is accused of stabbing a guy. He said he did it in self-defense. His wife told the police that that the victim did not have a weapon, clearly did not have a weapon. And at trial, they invoked the spousal privilege. So she was unavailable to testify, and so there was an issue like, oh, will this affect the Confrontation Clause? He can't cross-examine her statement because the statement she made to the police. But the Supreme Court held hearsay does not violate the Confrontation Clause when it's non-testimonial in nature. If a hearsay statement is testimonial in nature, then its admission will violate the right of confrontation. And then the Supreme Court concluded that Crawford's wife's hearsay statement was testimonial in nature, and thus violated the defendant's right to confrontation, as the defendant had no prior opportunity to cross-examine his wife. And then, but the big portion of the Crawford doctrine is the ability to cross-examine, and that and probably most importantly is whether the statement is testimonial or non-testimonial. So generally, a statement is testimonial if a declarant would reasonably believe that the statement could be used as evidence in a later trial. So you're kind of, when you go to the police and you make your statement, you're kind of saving that as evidence for a trial. But unlike the 8034 statements made for the purpose like medical diagnosis, those statements are not typically made to be used as evidence at a later trial. It's usually for the purpose of medical treatment or diagnosis. So that's why it falls within that hearsay exception. But yeah, that's the Confrontation Clause. It's got to be non-testimonial to not violate the Confrontation Clause. But if it is testimonial, then the person needs to be available for cross-examination. But if that person is unavailable, typically you won't be able to admit the statement unless you have one of the exceptions, like wrongfully making the person unavailable. They testified at a prior, they gave former testimony. The belief of imminent death. So, and statements against interest, but that's not really actually a confrontation issue because you're the one who made it. You can confront yourself, I guess. Yeah, but anyways, that is all. I hope you enjoyed. Hopefully that gives you a little heads up about what's going on with evidence, to help you get your bearings before, your semester. I guess your semester already started. My semester started. But yeah, enjoy. Have a good night. I gotta get back to studying. Yay. Peace.